Senate Bill 1558. Imagine this. A child is hurt while in foster care, and the family wants answers. The nonprofit agency involved points to its background checks, training records, and compliance paperwork, and says it cannot be held responsible unless the family can prove the agency failed a specific safety step tied directly to what happened. What the bill says it does. This bill says it protects nonprofit child welfare providers when they follow basic safety and reporting rules. The idea is to keep foster care providers in the system and reduce legal risk if they are meeting required standards. What it actually does? It makes it harder to sue the nonprofit organization itself for ordinary negligence. This means large foster care contractors can protect themselves with compliance records, while families lose some ability to hold the organization accountable unless they can prove a very specific failure. Who benefits? Nonprofit foster care providers, single-source continuum contractors, large child welfare networks with strong compliance systems, insurance carriers tied to those organizations. Who pays the price? Families trying to seek accountability after harm, children in care if problems are hidden behind paperwork, smaller providers that may not have the same administrative resources, the public if less court pressure means less transparency. Why it matters? When a provider gets public contracts and public trust, families expect real accountability if something goes wrong. If the law makes it easier for institutions to defend themselves with paperwork, then ordinary Texans may have a harder time getting answers, justice, or reform when children are harmed. Bottom line, Senate Bill 1558 makes foster care contractors safer from lawsuits, but it may leave families with fewer real tools to demand accountability when children are harmed.